So I will call us to order. We can begin with the...
Hold up,
Pledge.
we got somebody here. We're just getting ready to start, Brian. His attorney's on his way.
So this is the first case on the agenda. So we can always do the second case first if his attorney hasn't showed up yet. So
She'll just have to page through. They're gonna start with you.
They're gonna start with me?
Yes, and once we get started, you'll have to page through your
I'm still just opening us up. We just had the respondent come in while we were getting ready. So start off with the Pledge of Allegiance.
okay?
Pledge of allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
For the benefit of the respondent, my name is Drew Smith. I am the Code Enforcement Special Magistrate for the City of St. Cloud. My role here today is to be an independent fact finder, and I understand you have your attorney on his way. Don't stress out. We've got another case that we'll hear before yours, so you've got time. But my role is to be an independent fact finder, so I'll hear the evidence of the Code Enforcement Board. You and your attorney will have an opportunity to ask any questions you may have for the Code Enforcement officers. Once the Code Enforcement officer's part is done, then you and your attorney will have an opportunity to present to me anything you'd like me to consider. And when I've considered all of the evidence, I will enter a verbal ruling today. That ruling will be followed by a written ruling that you'll receive in the mail. Okay? With that, I assume you're going to testify. If you don't mind, I can wait until your attorney's here if you'd prefer, but I'm going to swear in the witnesses, so you're welcome to be sworn in now. If you'd prefer to wait until your attorney's here, I can swear you in later. If you raise your right hand. Do you swear from the testimony you give us the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And you may call our first case. Well,
Case
call the
nu-
second case because we're going to push the first one to second.
Case number 2020-1744, Carolyn Sellup, owner, location of violation 506 Massachusetts Avenue, St. Cloud, Florida. Violation, International Property Maintenance Code, Sections 102.1, 102.2, 108.1.3, 301.2, 302.1, 302.4, 302.8, 304.13, 304.14, 304.15, 305.1, 305.3, 601.2, 605.1, 704.1, 704.2. Description of violation, failure to prohibit but rather allowed an abandoned vehicle, miscellaneous debris in the exterior property area, high grass weeds, and allowing the residential dwelling to be lived in without proper maintenance and repair at this location.
Good afternoon. Pam Neal, City of St. Cloud Code Enforcement Officer. I am presenting this case for the property located at 506 Massachusetts Avenue. At this time, I would like to enter into evidence the following items: a copy of the International Property Maintenance Notice sent by certified mail to the owner and posted on the property and City Hall, a copy of the Statement of Violation and Notice of Hearing sent by certified mail to the owner and posted on the property and City Hall, copy of the PowerPoint presentation, a copy of the affidavits of postings, the certified mail receipts, a copy of the deed to the property, a copy of the code sections in violation, a copy of the costs incurred if the special magistrate finds the respondent in violation in the amount of $379.20. On September 11th, I received a call from the police department stating that a warrant was served at this location and they found numerous violations and they needed me to conduct an inspection. There were broken windows, damaged floor frames. There were broken windows, damaged door frames, holes in the walls, ceiling and floor, missing screens, exposed wires. Electrical panel was not marked. An abandoned vehicle. Exterior property has miscellaneous debris and high grass. I took 14 photos.
As you go through these photos, tell me what I'm looking at.
Okay. That's the broken windows and no screens. That's the door frames. That's holes in the walls. There's holes in the ceiling up there. holes in the floor,
Slow down a little bit.
more of the frames around the windows. There's exposed wires. Electrical box not marked. And that's the abandoned vehicle.
Go back to the vehicle for me. Abandoned because of registration, or is there other issues with the vehicle?
It was inoperable too. It was both.
Inoperable, what's your testimony as to the inoperability?
It didn't run. It hadn't been moved in a long time.
And you observed, what did you base that finding, what observation did you base that finding?
Well, I asked one of the people that they arrested if it worked at all, and he told me no.
Okay.
There's more of the accumulation. That's not a good picture of the grass, but I have better pictures later on. Okay. On September 14th, the building maintenance department boarded up the windows. I also went the same day and took some photos. And I took 3 photos of where it was boarded up.
Are the boarded windows part of the violation?
Well, no. On September 16th, an International Property Maintenance notice was sent by certified mail to the owner, posted on the property and City Hall. An affidavit of posting was done, and 1 photo was taken of the posting. On October 20th, a reinspection was made, and it appeared that no repairs had been done. The vehicle was still there with no tag and inoperable. The exterior property was still not cleaned up. The grass was not mowed, and I haven't heard anything from the owner. So I took 6 photos.
No improvement?
What's that?
No, there was no improvement at all, no change?
No, sir. That's a better picture of the grass. On October 27th, I posted the property on City Hall with a copy of the statement of violation, notice of hearing, sent by certified mail to the owner. An affidavit of the posting was done. I took 4 photos. On November 3rd, a reinspection was made, and it still appeared that no repairs had been done. The exterior property was still not cleaned up. The grass was not mowed, but the vehicle was gone. I took 5 photos.
What was the date the vehicle was gone?
Excuse me?
What was the date that the vehicle was gone?
November 3rd. On
that?
November 16th, the reinspection was made. Still nothing had been done. I still haven't heard anything from the owners, or from the owner, and I took 4 photos. The respondent is not here. It is the city's recommendation that the respondent be found in violation of allowing an abandoned vehicle, miscellaneous debris in the exterior property area, high grass and weeds, and allowing the residential dwelling to be lived in without proper maintenance and repairs at this location, and to have the exterior property area cleaned up, the grass and weeds mowed, and all maintenance and repairs completed by December 1st, 2020, or pay a fine of $250 a day until compliance is met. The city would like to also recover the cost incurred in bringing this case before the special magistrate in the amount of $379.20 to be paid within 7 days of the written order of the magistrate as well. And that concludes my presentation.
Just going through and looking at the printouts of your photos to make sure I don't have any more questions about them. And you said no respondent is present, and I believe, sir, you're here on behalf of Mr. Pugh? Yes. Okay, thank you. So no respondent present. I will find in favor of the city of St. Cloud. Find the respondent is in violation for allowing an abandoned vehicle, miscellaneous debris, high grass and weeds, allowing the residential dwelling to be lived in without proper maintenance and repairs. Order the respondent to make the necessary maintenance and repairs, mow the grass and weeds by December 1st, 2020. If not cured by that time, a fine of $250 a day will accrue until compliance is met. Leaving the vehicle out of that because the vehicle is still gone, right?
Yes.
Okay. Also order the respondent to pay the administrative cost in the amount of $379.20, which amount shall be paid within 7 days of the date of my written order. Anything else on this case?
Nope, thank you.
Case number 2020-1116, Brian Pugh, owner, location of violation 4201 Warner Lane, St. Cloud, Florida. Violation 2015 International Property Maintenance Code, Section 302.1, adopted by the St. Cloud City Code, Section 10-33, and St. Cloud City Code, Section 24-162A and 36.38, description of violation, failure to prohibit but rather allowed accumulation of solid waste, high grass, and exterior property areas to not be maintained at this location.
He's
I'm like,
queuing it up.
who's doing that? Okay. Good afternoon, Melissa Howes, Code Enforcement Officer for the City of St. Cloud. Again, I am presenting this case for the property located at 4201 Warner Lane. At this time,
Before, do you have a,
We would request a continuance. We've got photos that,
that way, so I can hear you. With the mask, I can't hear you. So speaking to the mic, you can leave the mask on if you're more
Okay.
comfortable. Just speak into the mic for me.
well, this will be safer. I don't talk very loud, so. And I think I'm 6 feet, except for the prosecutor over here. We're requesting a continuance. We've got photos that show we're in substantial compliance. There are still a lot of tires. We're not saying there aren't a lot of
Okay.
tires there. It's about approximately a third of them have gone. We also have a contract where they're being, whatever's not gone is going to be picked up on December 1st and transported elsewhere. And we would just like to show you the pictures of the rest of the property, because the rest of the property looks, we think, pristine. And the only remaining thing is the tires, and there were over 1,000 tires when they first made the code violation, and it's down about a third of that. But we do have a contract for everything to be picked up by December the 1st and gone.
Okay.
First, I'd like to show you.
Before we get there, let me engage a little bit with this, because I know, I think I know, I don't want to put words in the city's mouth, but I suspect that they're going to say, let's go ahead and proceed, get an order, because what I'm going to order here today, I'm going to give time to cure. And from a efficiency standpoint, I'm open to be convinced, but from an efficiency standpoint, where I am right now, your time, my time, his time, her time, everybody, your client's time, may be better served if we hear the evidence, and if you and the city agree on what's left to be done, we can just boil that into the order. I'm very willing to work with a client, with a respondent who's working towards compliance, and whatever time you need, we could get that in the order today and save everybody a trip back here if you think that.
Well, if we have a
might
hearing, we're going to defend that we're not in violation, that he is a Florida registered waste tire collector, that he has a Sunbiz, and that he's allowed to substantially put some tires there, and we're going to defend on that. Rather than defend, he's told me he would just soon work it out without going in, without having a possible code violation, resolve the whole matter with them being gone. But otherwise, we're going to
Understood.
put a defense on, and we prefer not to put the defense on if we don't have to.
Now I understand better, and now the city has the benefit of hearing that. Does the city have a response?
Yeah, please, if I could, Mr. Virginia. Excuse me. Your Honor, first of all, this case dates back to June of this year. The city wishes to proceed for several reasons. It's a serious threat in the city's estimation for some of the violations to the community. We did receive a request through my partner, Dan Manzares, from counsel for Mr. Pugh for a continuance. At the time of the information that was forwarded to me by text, the respondent's position was that there had been a 2/3 correction or elimination of the concern. That's contrary to the evidence and testimony that our inspector will provide to you here this afternoon. None of the violations came into compliance within the time specified, and due to the serious concerns to the community with regard to the tires and the other violations not being corrected in the time given, the city wishes to, at a minimum, get a finding on each of the violations here today. Understanding everything you've said is exactly accurate, there'd be time for compliance before any potential fine were to accrue should the magistrate find violations as has been cited. So for those reasons, and we're glad to see that you were able to attend today's hearing as opposed to not being able to be here at 3 o'clock. So the city would like to proceed based upon the issues at stake.
Okay. And counsel, I'm sorry, I didn't write down your name when you first said it. Could I get that again?
Sure, it's Ronald, last name Legendre. I say Lejean, but nobody else does, so don't worry.
I grew up in Louisiana, so I think I can handle that.
Okay, yeah. Actually, I went to school in Louisiana, and I grew up in the East, and I was very surprised when I got into Cajun country. Everybody there could pronounce my name perfectly.
You pronounced it right there. So do you have a rebuttal? And
yes, I do.
I'll tip my hand to you. I'm leaning, you're saying you're here and prepared to defend. I'm leaning towards going ahead and hearing it today for the reasons they stated. If it is a violation and it's a health concern, I don't want to put off what doesn't need to be put off. And if you're prepared and ready to defend, I'm prepared to hear you.
I have two concerns now. I noticed Mr. Manzares was not here, but I didn't realize it was somebody else from the same firm. My client has been represented by their firm through Legal Shield.
I'm sorry, when you turn around, I can't hear you. What was the...
My client, Mr. Pugh, has been represented by their firm through Legal Shield numerous times. And we feel that they should not be here in a prosecutorial manner,
Okay.
having represented them a number of times. In addition to that...
Before we move off of that one, if we're moving off of the representational issues, let's pause there so I can hear a response.
All right.
Well, this is news to me only insofar as I was not alerted to the fact that someone at our law firm, through a Legal Shield membership or otherwise, excuse me, can you just allow me a little bit of space? Thank you, sir. This is the first I'm hearing of it. I'm disappointed that this was not communicated to our law firm in the days and even weeks prior to today, but I certainly am fully capable of removing myself from the proceedings and allowing the city to proceed without me here in any form or fashion and allow Officer House to move forward. So I don't know that, I don't have anything to corroborate the conflict, but I certainly don't need to be involved if there's an issue. I don't know that our firm has been contacted on this issue.
I understand, and that's...
Sure. Certainly
So
I have no knowledge of that.
I won't say I'm disappointed because it's not my problem, but I wish it would have been communicated to them ahead of time.
I would note I've had several communications with their office.
About that topic?
None of which I have had contact, and I've just requested that they call back. That's as far as I got.
Well, but this is the kind of issue that if I were a party, that I would bring up ahead of time. That said, I now have a concern that comes back, and probably why the argument was raised, but it brings us back to this idea of continuance. And I'm trying to be fair to all parties, and now I'm trying to make sure I'm being fair to the city. You have an attorney here who is stating they're prepared to present a vehement defense. As competent as your code enforcement officers are, they are not attorneys. I also have a claim of possible conflict that you can't refute or confirm. I don't hold that against you, but I also don't want to see you put yourself in a bad spot. So I think you're doing the right thing in saying I can step back, but I don't know that I'm comfortable as the hearing officer putting the code enforcement officer to present testimony that is, I fully expect, going to be well defended by an attorney. I don't think that's fair.
Excuse me, if I can just have the microphone.
I understand you don't, but I'm the hearing officer and I do.
Sure. Just to further inform the magistrate, I received a text from my partner, City Attorney Dan Manzares, yesterday morning asking me to contact Attorney Lejean about the messages that he had left, or message, I'm not sure if it was multiple, with Mr. Manzares' office. There had been an inability for the two to connect, apparently. I called at 11:30 in the morning yesterday and spoke to a legal assistant at Lejean and Lejean, as I recall the name of the firm. She was lovely on the phone and took both my direct dial to my desk as well as my cell phone. And I left a very detailed message who I was, why I was calling, that I was Dan Manzares' law partner, and to call me at any time to discuss the matter. Heard nothing. So to address that issue of why now a conflict is being raised, and I'm not refuting that that is a situation. There may be a technical appearance of a conflict based upon a Legal Shield membership. Our firm is the provider firm for over 60,000 Legal Shield members, so I have no reason to dispute that. But my understanding, and I'll allow the code enforcement officer to speak, but I believe, based upon what's at issue here today and the violations, multiple, that are part of this case, that, I think the city is intent that they'd like to go forward. I don't know, quite frankly, how much lawyering is going to be necessary.
And that is my concern. It is not about the competence of the code enforcement officer to get the evidence in. If there are legal issues raised, if there are statutory issues raised, if there are case law issues raised, that's the lawyer's bailiwick.
Does he have proof?
Well, the issue with the conflict is that if there is an actual conflict, that's not for me really to even determine, because ultimately it's a rules of professional conduct issue for your attorney. Right. And so, like I said, I believe he is doing the right thing with an allegation out there and saying, I will not participate. So I would not feel comfortable, and I would not ask him to, and even if there's not evidence that it exists, if there is a question, what we do as lawyers is say, I got to answer this question before I move on. And so that's the problem that we're in as to that. And then the other one is, if there is any lawyering, there is nobody to respond to. And so if I proceed with this case, I may be giving a significant advantage to the respondent in this balance of fairness, because if there is a fair amount of lawyering, and Mr. Lejean seems like a fairly competent lawyer, then there's nobody to respond or rebut that. And I may have a case where all the evidence in the world says there's a violation, but I'm not comfortable on the law, and therefore the respondent is found not in violation on a legal principle because there wasn't a lawyer there to present me the other side.
Understood. If you allow me 30 seconds to confer with the inspector as to what you'd like to do.
Let them confer before you talk to making sure he hears everything you say.
Okay, I've counseled with Inspector Howes, and she wishes to proceed on behalf of the city. I will place on the record that based on the allegation that my law firm is disqualified from this particular proceeding, I will not participate. I will not give guidance to her with regard to any legal questions that come before the magistrate in this case, in an abundance of caution ethically for the firm of DSK.
So you're back up, Mr. Lejean?
I would feel much more comfortable if there was an attorney on the other side. There are things that when you have a pro se individual, which is basically what we're going to have, or as an attorney, you do things that you might not get away with if there's an attorney on the other side, but you're obligated to by representing your client to the fullest degree that you can, especially as what you can get into evidence and what you can't get into evidence and some of those items. I would note just one thing, and I can't find the paper because I wanted to show you the paper, but if they're worried about mosquitoes or things like that in those tires, he has 2 system sprays, which he's required to do under this system, One is a Suri, which he puts in there to make sure our larvae die, and another one is a spray. So if that's the health concern that they're worried about, that matter is taken care of in due course of being a waste tire collector. But that's the only thing I would mention of their immediate concern because of tires. Anyway, note that there's a lot of tires still there, and they're down by about a third. If it was two-thirds was the comment I think opposing counsel mentioned, then it was misinterpreted or I misstated it because it's only about one-third is gone. As far as he left a message, he may have. It sounds just like my paralegal, nice, sweet lady. But if it was, she never gave me the message, so I did not call back, as I certainly would have.
The phone tag, that doesn't influence me one way or the other. It happens, so it is what it is. We are where we are. Claudia, I want to confer with you. When can we get the room? How available is this room?
I would have to ask them because they have other meetings.
Is it possible to run out there and ask them when this room, give me, I know next week is Thanksgiving, give me the next week, next 7 days of availability for this room?
Okay.
I won't be available after that. I'm on vacation for 2 weeks.
When are you available this week? When are you available this week?
Anytime up till Thanksgiving.
Okay, that's what I'm looking at, is up until Thanksgiving.
Okay, I thought you said after.
No, up to, Claudia. If you misunderstood, it was up to.
I misunderstood.
Once we get a date, if I could call my office to check my availability.
Sure, absolutely, no problem.
FYI, we're trying to set something up for next week. That department is not available next week. We're both out on vacation.
So microphones and stuff, can we at least have those?
No.
So no microphones, no nothing?
Nobody's gonna be around.
She believes the 21st, the 24th, the 1st, 2nd, and 3rd.
It's all dates next week. All right, well, tech's not available next week, so. Rescheduling doesn't look like it's a very valid option for me right now, because I'm not, if I wasn't hearing health and safety concerns, you would have gotten probably a little bit more willingness from me. I'm reluctant whenever there's health and safety concerns to not hear that case. But rescheduling, at least for a short time frame, an out-of-sequence hearing, a short time frame doesn't look like it's going to happen. Let me take another crack at finding a resolution that can let us all move forward. And I've got to look to you guys because you don't have a lawyer right now. Your client is saying that the issues will be resolved by when?
He has a vehicle coming in with a vehicle to pick everything up, and it's supposed to be gone December 1st.
That's the tires. When you say everything, what do you mean?
Everything, well, I think there's about 9 pallets that are out there, as I recall. And everything else has been cleaned, and I can show you the pictures, everything is pristine.
So your contention is that the only thing even that we're talking about, and I know you're not conceding anything, the only thing we're even talking about is tires.
And I think it's about 9 pallets, because I was.
Oh,
talking
wood pallets,
yesterday,
okay.
And they said there were 9 pallets.
The tires are the health safety issue anyway.
And that was December 1?
Properties, correct.
And that was December 1, you're saying the company's coming in?
Well, they're coming in with a truck before that, for him to fill it up, and they take it off December 1st.
So by December 1, everything's gone. Code enforcement, what they're saying is really what you were going to ask me to order if we'd proceeded.
I agree. But what about a finding? Because
I understand if it doesn't happen, and that's why I don't have the stick of a finding, I understand. But if you get out lawyered without a lawyer, you have no finding, and they walk away saying, well, we might not just do what we're offering to do right now because the magistrate just ruled in our favor. So I am looking at this as if we can resolve the issues, everybody keeps their word, and we resolve the issues, everybody wins. And so instead of the stick of that finding, if you don't do it, I can fine you, if they do everything they said, this boils down to $267.70. If we don't come back for hearing, they don't have to come back for hearing. You don't get your $267.70, but you also don't have to pay me and Jack for that part of that hearing. So, and again, you can't look back at him now.
I'm not.
No, I know you weren't. I'm not saying you were. I'm preceding it to make sure it doesn't happen after I say this. Is my suggestion here is that if the parties can agree that if they do what they say they're going to do by December 1st, you'll dismiss this case. You lose out on $267.70, but they have a reason to do it, and everybody gets what they wanted at the end.
And if it's not done by December
We're back in front of me.
next month, you can say.
You can schedule it whenever you're prepared to schedule it.
Well, it's in our next meeting is what I'm saying.
Yep.
Okay.
Counsel?
December-
Do I have everybody's word? They're going to work really hard to make this happen.
Can we have it in writing from them?
I can't, it's on the record here,
Okay. And it's in our minute. Okay.
and I'll remember if I have to hear it again.
Oh, yeah, absolutely.
My client says everything's been taken care of. The final catch had been the payment, and his mother has stopped by to the place this morning and has made the payment.
Okay.
So we know everything is.
Well, if everything happens the way that he's promising, he'll save himself $260.70 potentially, so let's get it done,
Thank you.
okay? Then I am going to grant I'm going to go ahead and grant the motion for continuance that was made. Hopefully it's dismissed before it has to come back to me. Everybody okay with that?
Continue to December's meeting, correct?
Whenever the city renotices it.
Okay. Yes, sir.
We'll get the notice in the mail. Is that?
Yes, sir, that's why I made that point. The city will renotice that meeting because I don't, even on a continuance, I'm uncomfortable with us continuing here and then expecting everybody to show up. I prefer for a formal notice to be sent again.
Thank you.
Yes, sir.
I don't expect to see you again, so thank you very much.
Thank you. It was a pleasure meeting you.
Unfinished business, request for reduction of liens under 50,000. Case number 2010-2057, Elaine Sir, owner, repeat violation, location of violation, 215 Oregon Avenue, St. Cloud, Florida.
Mr. Magistrate, Jack Morrison for the city. This is a request for reduction of fine lien settlement under $50,000. The respondent, Elaine Sear, property at issue 215 Oregon Avenue. Case was heard some time ago. Date of hearing, if I'm reading this correctly, was 2010, August. Compliance was reached in September of 2010, and so a total fine accrued back at that time of $7,600, $7,655.54, and the property owner, Ms. Sear, has reached an agreement proposed with City Manager Sturgeon for a payment to the city of $2,500 as full and final payment to be made within 30 days as a settlement of the matter. And obviously, if the The agreement was if the payment were not to be made within the time by your order, that the fine would revert back to the original amount.
Is that it?
That's it.
I will approve as agreed between the city manager and the respondent.
Thank you, sir. Nothing else from the city.
Anything from you, Claudia?
New business, none. Next scheduled meeting, December 16, 2020.
Thank you, everybody.
Oh, you have the folders.